Hello. We've got...
I believe this is, Your Honor. I'm the special master.
All right, thank you. We've got the special master, Ms. McConkey. Who else?
We have Jeremy Bishop here as well.
I'm sorry, say your name again.
Jeremy Bishop.
Thank you.
Casey Borlick, guardian ad litem.
All right, thank you. I think we've got everyone. For the record, Orange Chamber is having a telephone conference on Wolferts versus Wolferts. The issue has been raised by the guardian. I do see a number of other things have come in the file. Those have not been submitted for decision, so my intention was merely to address the question raised by the guardian. Are the parties prepared to proceed with that?
We are, Your Honor. Yes, Your Honor.
All right, I'll hear from Ms. Borlick first.
Yes, Your Honor. I will not take the time, of course, to go through all the arguments that I made in my original request because I will assume that the court has had an opportunity to read through those.
I did.
But I will like to supplement it just briefly. Since the filing of that document, I still have not had the opportunity to speak with my clients in a confidential and a private manner. In addition to that, I have had the opportunity to receive information from Kansas DCF regarding the proposed placement of Darren and Tracy Haddock of the girls in Kansas. Again, I will reiterate that I do not have the input from the girls at this time regarding this placement, but based upon the information that I have been provided from Kansas DCF, I would be recommending Tracy and Darren Haddock as the placement for the girls at this time. I do have, responses to the other documents that have been filed, but again, we can wait, and I'm assuming that we will address scheduling or the like as to these other documents. I would just ask the court to have the opportunity to respond to those arguments posed by the other attorneys present before the court today.
All right, thank you. Let me hear from the special master.
Your Honor, neither of the client's attorneys have involved me very much in this matter since it left the juvenile court. I have read all of the documents. I have met with Father's Counsel when we were in juvenile court. I have spoken with the guardian ad litem. I do have concerns and would support that at least until some therapy is underway, that the children be placed in a setting not in Father's home, at least until some reintroduction happens and we know where these kids are.
All right, thank you. Let me hear from Mr. Wolferts' counsel.
Thank you, Your Honor. The concern again that we have, I think initially to start off with was the TRO hearing, which was my request for supervised parent time and no contact order. Ms. Borlick showed up, not really being on the case, and presented an alleged plan that Kansas Family Preservation had. That plan, in fact, did not exist. I have since supplemented the court with their actual plan. The plan was never to remove these children from Mr. Wolferts' home. They have been in his home, and they are going through therapy. Ms. Borlick has talked to the children's therapist who recommends the children not be removed. Ms. Borlick had the opportunity to talk to the children, and never once, at least as far as I can see from her recommendations, did she ask them how they felt about the placement. She asked them if they were safe, and they indicated that, in fact, they were safe and they were fine. And then that was it. And then she demanded to talk to them again at a different point in time, and my understanding is that she has yet to call my client to reset up that time. My communications with Ms. Borlick were that she had the authority to contact my client on one occasion to discuss the case, and on further occasions to set up times to talk with the girls. My client says after that initial phone call, he has not received a single phone call from Ms. Borlick requesting time with the girls or to talk to the girls. So I'm a little bit surprised at this request when she hasn't even called to set up that time. But nonetheless, after having reviewed the Kansas plan, there was no plan to remove the girls. Again, my client contacted Family Preservation, contacted DFS in the event that the girls were hostile in the home and that they needed to place with another family. It was a backup plan. It always has been a backup plan. And I now actually have the evidence from Kansas that affirms that it was simply a backup plan. I have another greater concern, and that is removing children from a home of my client when my client hasn't done anything. He has constitutional rights to provide care and control for his children. And let's not forget how he came here. It wasn't my client's doing. He did nothing wrong. It was the girls who allegedly ran away and then were concealed by the respondent. And so I don't see a constitutional basis or a statutory basis for the removal of these children. And they've now been in his home for, I think, 6 weeks now. So to remove them, I believe, would be harmful. And their therapists who they've been meeting with also would indicate that it would be harmful. And so I would deny the request or ask the court to deny the request and reconsider because the information provided at TRO hearing was not accurate. It was not supported. It was based on a triple hearsay email that has now been rebutted by the actual person, the actual family preservation plan, and that document's been submitted to the court. And so based on that, I would ask that the girls continue with the therapy that they've been receiving and that they remain in the father's home. At this point, there is simply not a constitutional basis or statutory basis for their removal.
Well, the motion for consideration isn't ripe for discussion today. It hasn't been submitted for decision. It was filed just on the 26th of April. No one's had a chance even to respond to it. So I'm really not inclined to entertain that request today. I scheduled this for a telephonic just so that we could talk about the guardian's concern. Let me hear from counsel for Ms. Wolferts.
Yes, Your Honor. We've been very concerned about the fact that even though the court ordered that my client have contact with these girls, and we've been trying to set up something that's supervised as the court orders, that even though we've written a number of letters, we've never received one response from that. And I think this is really goes to show what we are concerned is happening here. I think that the fact that it is 6 weeks that's gone by that the guardian ad litem is claiming in her documents that she's been unable to even talk to the girls, we're claiming, and we're claiming that we haven't been able to get or arrange for any type of supervised telephone contact with the girls, that I think it seems as if there's been some sort of a delay, hoping that the girls can be influenced in a way that we think is inappropriate by this reunification program. Now, I think that the court should know that this Jocelyn Parrish is someone who is associated with the reunification program. She is not an independent therapist that the court had in mind. And I don't know if the court knows, but we did go to some length to try to find an independent person to give us an evaluation of the girls, because if the court has had an opportunity to read her report, she makes a claim at the very top of the report. I'm here because these girls have been alienated against their father, and she makes all of these presumptions without ever having the girls evaluated for that. And so we're really concerned that this has continued to happen and that they've been continued in this reunification program with this reunification counselor when it seemed to us that it was the intent of the court that stop. And we have been unable to have any contact with the girls, even though we have attempted to try to arrange contact with the girls. And we've never had a phone call back or anything from the letters that we've sent. We're very concerned for the girls because I have talked to a number of therapists in the area, and I'm told that this is is not a program that is accepted by the psychological community at large. It's just very few people who accept that, and it just seems that what's been going on is exactly what Ms. Borlick has suggested in her documents, that they're keeping the girls away from us so that we can't get the mom any contact, and it's important for the children to have some supervised contact with their mother, and that hasn't happened, not since the order. And it seems as if it's a tremendous concern for us. We're concerned about their well-being. We suggested to the court the name of an evaluator that we got from the University of Kansas, or Kansas State University, I can't remember which one, who was associated with the university, who does these kinds of things, and we just received an objection to his name with no other. The court had asked us to look into it. We looked into it. We found someone, and there was an objection to his being used, and so it's just more time that goes by, and now it's been 6 weeks. And frankly, I think my concern is for their safety. I think that we really don't know what's going on there, and I think the court's going to have to take them. I think the court, from our perspective, the court should take them immediately and place them immediately in Darren and Tracy Hadlock's custody today, so that we can so that the guardian ad litem can get a hold of them, so that we can actually get some contact with these girls. We can ask the Hadlocks if they would be the people who would be interested, perhaps, in being the supervisor for the telephone contact, or whomever Ms. Borlick believes is appropriate would be fine with us. Interestingly enough, counsel suggested that these girls were left alone, to talk to Ms. Borlick, but after reading the report from Jocelyn Parrish, it states that the parents left the room, not Ms. Parrish. And the girls clearly, would understand that she was, in a position, trying to reunify them to perhaps someone who is inappropriate to have them reunified to. So I'm sure they felt like they couldn't honestly talk to the GAL. To think that 6 weeks has gone by and we still haven't had the GAL even have a chance to talk to these girls without someone there is amazing to me. And we're really concerned and worried about their safety. We want access. We want access today. We want to have time when my client can talk to them today. We want to know, who the supervisor is, so that she can do that today. We're very, very worried about the delay.
Thank you. Let me hear if the guardian has any response.
Yes, Your Honor, just quickly. The counsel made the claim again that the plan did not exist. This court has all the information that I have ever had regarding the plan. Again, that plan was not set forth through as counsel would claim, here's from a Snake Canyon worker to this individual or that individual. It was sent to the court, or the court has a copy of that email. Again, it was from the ICJ worker here in Utah, and it states a specific plan, as specific as I know about, and this is all I've ever represented to any court, the details that I knew about the plan, which are the plan is the girls will remain in the father's guardianship. However, they will be placed with a family friend until they can be reintegrated. Also, the families will be working with family preservation to work on this goal. The only other information that I have regarding this plan was the fact that the father has given some names to Kansas DCS. I had those 3 names given to me. I went through my investigation as far as the placement goes with them, and that's all I've ever known about the plan. When I discussed with counsel about the plan, again, I only gave the details that I have, which is what I have given to the court. The juvenile court relied upon it. I have given that order to this court indicating that. The DCFS in Utah relied upon that. This court has that report. I have not made any representations regarding the plan that I have not backed up with documentation, and the only argument that has been presented to the court is that. And those are the only details I have. The additional details obviously would need to be determined by all parties and members to this matter, and those that are interested in helping the girls. Mr. Bishop indicates that that the children's therapist, that I talked to the children's therapist and that she says that they are okay. This individual is not the children's therapist. I talked to her specifically when I was discussing with her the issues regarding my being able to speak with the children. She indicated that one of the first things that I asked her was whether she had ever met with the girls alone outside of the presence of the father. She said no, she has not met with them alone. She could not give any representations as to how these children were feeling or how they were doing really without having the father there in their presence. She indicated to me that she had met with the family 2 times. This is not the children's therapist. We have zero verification that these girls are okay and safe. The girls did not indicate to me that they were safe. The girls did say to me that they were okay, and they said that in the presence of a therapist who's working for the father and is associated with the reunification for High Road. When the first thing that I did when I tried to talk with them, and I went through that in detail in my report, Your Honor, but again, the first thing I asked them is if they were okay. They did say yes to okay, but again, this was in the presence of father and Jocelyn. I then asked if they could go away from them. The first thing she said to me was, they won't let me. Then she clarified that it was the people there, so meaning the therapist and the father. So they wouldn't let her have a private conversation with her. As soon as I had that information, anything else that I would have tried to glean under those circumstances would not have been valid. My absolute hope is that when I talk to these girls in private, in a confidential setting, which I am allowed to do and am required to do under the statute, that I hope that they tell me that they're okay, that they have worked through whatever issues were there with the relationship with their father. I hope that everything is fine, that they're okay and they're safe. But I do not have any verification of that. This court does not have any verification of it, and frankly, nothing has been presented to this court that could verify that. When counsel talks about the fact that I have not called back his client to talk with him about these issues, I left after requesting to have a private consultation with the girls and having been not allowed to have that. I left counsel 2 messages indicating that I needed to hear back from him or his client to facilitate and allow and to help private consultation with his client happen. At that point, I am not going to contact his client to try and push the issue as he states in one of his documents, I was bullying him and threatening him. If requesting that I have a conversation with my clients in confidentiality is bullying and threatening them, if my requesting that I have a client consultation in private, and then the only thing that I said to him was that I would seek immediate court intervention to talk with my clients, not have them immediately removed. Even then, this court has already ordered that the children be outside of the home, but never once did I threaten immediate removal. What I indicated to them is that if I was not allowed to speak with my client as required, I would absolutely, no question about it, be seeking this court's help, which is what I am doing by having filed that document and having this conversation today. Counsel indicates that his client hasn't done anything. Your Honor, there are findings of emotional abuse. This individual emotionally abused these children. I met with them on numerous occasions in which they went to great detail to tell me the things that had happened to them in their life. They have been very concerned that they had a previous guardian ad litem that did not listen to them, did not even meet with them, would not be their voice to the parties that needed to hear what needed to happen, that they had very great concerns in the failings of this system. Your Honor, it was important that I have a conversation with my clients in order to ascertain whether they are safe and okay. Counsel continues to talk about this idea that they were concealed by respondents, that they were forced to run away by respondents. I have in front of me now and can provide to the court and will do so willingly, and I think it's absolutely appropriate. Again, this journal entry that was discussed at our last hearing, in which it states, I still really can't believe we ran away. But more than that, I'm upset that Mom and Britt would have forced us to talk to people who wouldn't listen. Me and Danny have talked about this hundreds of times. And again, it goes into the fact that that Brittany and the mother tried to get them to talk to officials, have them talk with another guardian ad litem, have them talk to psychologists. In all of my meetings with the girls, they every single time indicated to me that their mother had nothing to do with them having run away, and the mother throughout the time that they were on the run requested constantly and consistently that they come forward and allow the legal system to do what it needed to do, but that they refused to do so because they were so afraid of what would happen when they went home. They actually told me and believed that they would die if they had to go home. Another journal entry. I know the end result of me dead. I would rather kill myself than be the result of his abuse. What we dealt with before just scratched the surface. I can feel it. Your Honor, again, I sure hope that these girls are okay. I hope that things are fine in their father's home. But we do not have any verification of this. I would ask the court today to order that I be allowed to talk with my clients in a confidential and private setting immediately. Again, the girls were talking to me, even though it was indicated to me that they were outside of the presence of their father at that time. They were on his personal cell phone. They were just around the corner from him and this other individual who was saying to me, do not interrupt or intrude or probe. An attorney on behalf of these children not allowed to probe into whether or not they are safe under the circumstances is appalling. So, Your Honor, again, I would ask that I be able to fulfill my requirements to this court, which is, at this point, to make a recommendation as to a placement outside of the home. I have not been appointed on this case. I would ask that I be allowed and given the opportunity to complete my assignment as per this court, complete what I need to be done in their best interest, that I just have the opportunity to speak with them in a private, neutral setting so that they can indicate to me whatever they need to indicate to me, that everything is fine with that everything has been accomplished. But then in addition to this, that the court ordered that the girls, again, not have any more therapeutic interaction with the individuals associated with the high road to reunification. I spoke with Family Preservation Services. They indicated to me that Jocelyn, this was indeed related to the high road to reunification therapy, that she had not been referred by them, and so I would just ask, I would love more than anything that they be in therapy and that I could have, and that all the parties here could have verification that they are doing well, but it needs to be, again, by a neutral, independent individual that can let the court know this, that the court can understand that these girls are fine, that they are doing well. So those are my requests, that I be able to speak with my clients immediately, that they be removed from the home so that, again, they can be in an environment in which they can deal with whatever they've been dealing with in their life. I would add one last thing. Prior to even the requisition hearing, prior to today, I sent recommendations to Mr. Bishop in which these are some of the things that I indicated to him. I send you the following recommendations for settlement. Hopes of coming to an agreement in the bigger picture, best interest of Sydney and Danielle Wolferts. They are wonderful young ladies who are smart and determined. They are both truly capable of many future successes. They have spent a lot of time talking with me about future goals and ambitions. I am hoping that by coming to an agreement, we will be setting these girls up to achieve these aspirations. I then said, I gave my recommendations, which was that they be outside of the home of the father, but that their parent time with him be supervised, that they be outside of the presence of their mother, that their parent parent time be supervised. That the girls have assessments by a reunification specialist or another reunification therapist as agreed by the parties to determine what, if any, shared responsibility exists for interspousal conflict and the psychological effects it has had on the girls. Assessment of the girls by a reunification specialist to determine what, if any, negative parental influence the mother has had on the girls' relationship with their father. If the determination is made that there has been negative parental influence by the mother and that this has affected the father and the girls' relationship, that they be put into a remedy protocol if deemed necessary by the reunification specialist. Again, on and on I go through all of these recommendations, and then again, finally, these recommendations are set in good faith with the hopes of coming to an agreement that the girls will willingly participate in and cooperate with. If we have the approval of the girls, I truly believe that the likelihood of improving the relationship with their father is greatly increased. Again, throughout this process, I have wanted more than anything for these individuals, these girls, to have an appropriate relationship with their father, and that we set that relationship up for the very, very best success. So, Your Honor, in hopes of coming to that endpoint, I make the recommendations as I have today, that they be placed outside of the home until an evaluation be completed, and until the recommended treatment and therapy, and the individuals working with them, until they recommend that girls go home with their father.
And does the guardian have a recommendation for where that, or who would conduct the evaluation?
So, Your Honor, I have had an opportunity to meet or to discuss the evaluator that the petitioner, that the mother and her counsel recommended. I have not talked to him yet. I was waiting to hear more from whether the father agreed to that or not, and so at this point I would need to verify that further, but I'm happy to do so. But I also know in the area here, Marina Money, who has done a lot of work with parental alienation, and that I believe that she would be a spectacular choice to do that evaluation as well.
And did Kansas have someone in mind as part of the plan that they had worked out?
No, I don't believe so. I don't believe that it had ever gotten to that point. I don't believe that that the details had ever been gone through to that point.
But you said Ms. Money, correct?
Yes.
And she's here in Utah?
Yes, she's here in Utah.
The reason, Your Honor, we had thought of Dr. Lassen, because my client is responsible, according to the court order, to assume and pay for those costs, and so we were thinking it would be better for us if we could find someone in Kansas, and so we've made a diligent search in Kansas. I'm happy to talk to her to see if she's willing to have Ms. Money travel to Kansas if the court is inclined.
Your Honor, the problem I had with their proposal was, and I read through the CV, he had zero experience in parental alienation, which was what the court ordered to look into.
But you don't take exception to the recommendation for Ms. Money?
I don't know of Ms. Money. I guess I'd be more than happy to look into her. I know I proposed Elisa Hansen as well as Natalie Malovich. Natalie Malovich is a pretty well-known evaluator here in Utah. Those are both Utah therapists.
I want someone who's experienced with reunification. I mean, that's the particular issue that we're needing to address.
I'm happy to talk with him again, but he is actually someone who's associated with the university, and when I gave the facts of the situation to the head of the department, that's who he said would be the person. But I'd be happy to talk with him again and ask him specifically about his parental alienation expertise in reunification, but I understood that it was my understanding that he did have that, but I will check and be more specific about it.
All right. Let me ask Mr. Bishop, why can't I get a private conversation with the guardian and these girls? What's the holdup?
But, Your Honor, my understanding was they in fact did have a private conversation.
Well,
the girls were not in the presence of...
I mean, the guardian would know, and she's saying she didn't. What's the problem?
And Your Honor, I'm saying that they did. They had a private conversation in which the guardian asked them if they were doing well, and then said, I would like to set up another phone call, and the girls indicated that they would be more than happy to talk to her, and one of the girls even indicated that she was busy that week, can we talk to you next week? And Casey said, no, I need to talk to you now, but I guess my concern is she had the opportunity but never said, how do you feel about this placement? How do you feel about this? She didn't even take the opportunity to ask them. And then after that point, I talked to my client and he said, no, she hasn't contacted me to set anything else up. My client obviously has concerns because during the course of the ICJ proceedings, the guardian ad litem stood up in open court in front of the two girls and openly called my client an abuser. She's clearly taken sides, and I feel like she's deviated from her responsibility to not treat the parents and children as adversaries, and that's what she's done in this case.
Your Honor, we filed.
And if I may finish, I let everybody else finish their statement. If I may finish my response.
Go ahead.
The girls and the family have been meeting with Jocelyn Parrish, who has zero connection to the high road. I don't know where this claim came from. She has a practice in Topeka, Kansas. She was recommended by a state president and bishop back there to Mr. Wolferts as a family therapist to help the reunification. That's what they're doing. The high road protocol lasted 4 days. It's over. It's done. There's no need to even discuss it anymore. It's over. It occurred. They are now doing reunification therapy with Dr. Parrish, who works together with her husband. They're both PhDs, and they're working to reunify the family. I don't understand why we need a new therapist to come in and talk to the girls. I guess if the court wants that, we can do that. But the reality is, the high road's over and done with. It's over. Dorsey and everybody else that these people are upset about is out of the picture. It's done. It's over. We're now trying to work on the family relationship, and that's what Dr. Parrish has been doing. And her concern, Dr. Parrish's concern that she's raised is the girls seem to be doing well. She's met with the family. They have positive discussions with each other, and doesn't feel like that the progress that they've made, it would be helpful to now remove them out of the home. She hasn't seen any signs that would indicate a need for removal in the reunification process. And that's all we're saying. And that's why they keep bringing up this high road thing. It's over. Dr. Parrish has no connection to the high road. I would love to see any documentation that contradicts that. It's simply not there. It's not true. And I don't understand why there's such this fight and push for everybody to get the girls out of the home. The girls are doing well. They're doing well in school. They're involved. The girls are going on dates. They have a normal life for once, and now we're talking about disrupting that again. So I don't have a problem. I guess my understanding of Ms. Borlick's responsibility and the court order, and I've listened to the audio a couple times, where she was involved to discuss a family and find out what family would be good for the girls, which I think she's done. She's made a recommendation. I don't see why her further involvement is necessary. If there's a safety concern from the girls, I think that would be dealt with by Kansas DCFS, and they don't have a concern.
Your Honor, this is Kathleen McConkie. We put before the court a motion to ask that the court appoint Ms. Borlick as the GAL. As the court knows, from the last hearing we had, the petitioner claims that he's impecunious, that he can't afford a GAL. My client is not working. There's been abuse claimed, and so it would be appropriate. I thought the court had said they weren't going to hear that today. If the court wants to hear that, I'm happy to respond to that motion, because we think it would be extremely important to have Ms. Borlick, who's been involved with this case, remain. I think the problem we have here is Mr. Bishop doesn't like the fact that the GAL hasn't agreed with his position. And the GAL's duty is to the girls and their well-being, and not to either party, either the petitioner or the respondent. And that's exactly what she's been doing. And I think it's really difficult because he keeps on claiming that she hasn't been even-handed, but it's because she doesn't agree with what's been happening, and because she's been talking to the girls, and the girls have given her substantial information which indicate that they have been abused, and I think it's of grave concern to her. The other thing I'd like to suggest, Your Honor, is that if you look at the parish mental health and life coaching notes that counsel for the petitioner provided to the court, it says, met with the Wolferts for a second session in order to assist them in the process of uniting as a family. And then she says, after significant trauma resulting from false accusations made against Brian Wolfert by his ex-spouse, mother of Danielle and Sydney. So there's the presumption, Your Honor. They found someone that presumed that the girls had been lying, or at least had run away for no reason, or they presumed that my client somehow had alienated the girls without any evaluation whatsoever. So she goes into this as a therapist with not being someone who is, who doesn't have an agenda. This person has an agenda. Then she goes on to say, the girls were recently abducted by their mother for approximately 18 months. We heartily deny that, absolutely categorically deny that. And I think that that's not what the girls have told Ms. Borlick, and it's not what Ms. Borlick has just suggested to the court. And so, another interesting thing, Your Honor, that if you look at that parish mental health attachment that was provided, a statement from the girls' current high school principal attests to the high quality of work and well-being of the girls at their current high school setting. At the last hearing we had, the petitioner claimed they were so far behind. And yet, when the principal talks to this person, he's saying that they have high quality worth of work. So we're not getting a true and accurate statement from Mr. Bishop on what's happening with these girls. Then she continues to say there's been continuing bombardment and harassment by those in this family. And I think, well, we haven't even had a chance to opportunity to talk to the girls. And so her view of harassment is the fact that Ms. Borlick has tried to get in touch with these girls, which she has to do because that's her duty to do. We're asking the court to have her remain because I think that she understands the history. She's talked with these girls. I have never had any indication that she is in any way pro or con towards any of the parents. I think what she really is interested in and has always been interested in is the safety of these girls, and we're concerned with the safety of these girls. I think that if the court looks, it talks about what happened with the telephone call, and it does not sound like she left the room because it says, and listen to her language. Brian Wolfert asked that I speak with Casey Borlick and provide her with information concerning the girls' welfare. I did so, but then she demanded that I speak with the girls. I mean, it doesn't sound like she demanded. I think she asked to speak with the girls, stating that she was their lawyer and that if she did not speak with them, there would be a negative consequence for Brian. So Brian gave his permission, and he and Angie left the room. It doesn't say that she left the room. She didn't say we left the room. And they waited in the outer office while each girl in turn spoke with Casey Borlick privately using one of our offices. I mean, it's privately from them, but it sounded to me like she remained. I mean, I don't think these girls were ever out of the hearing of someone that they felt was not interested in what they cared about or what they wanted. I think it's unbelievable when the court said, we're going to have immediate contact with these girls, get together, get a supervisor. We've been trying to do that, and 6 weeks has gone by, and we haven't been able to do that. I mean, it seems to me that's a breach of the court order. We really, really, really need to have contact with these girls with their mom. And we really need to get them out of that situation. If, in fact, it's decided by this court that they're not in jeopardy, then the court can always place them back. But we need to get someone who's completely separate. That's why I got Dr. Lassen, because he has such a good reputation in the community. But we're willing to talk about other evaluators. But we need we want the girls removed, and we want them removed today. We don't want one more minute to go by with all of this because I think it's a strategy, Your Honor. It's a strategy to keep them there, to try to get them so that they somehow believe that their concerns were not valid, and that somehow Miss Borlick was not really someone who was concerned about their best interests. We want them out of there. We want them out of there today, and we want to have someone evaluate them. And the court can clearly determine who that is. But I think we found someone who's a professor at the university who does a lot of these kinds of things and would be fine to do that. Who understands parental alienation, and he understands unification. So if you would like to go with him, if everyone would feel comfortable with that, we'd be happy to set it up right away. If not, I'd be happy to call Marina Money. But let's get something done immediately with no more delay.
Well, the first thing that needs to happen is I want the guardian to have a truly private conversation with these girls. I'll order that, and I'm not happy that it hasn't happened. If, after that private conversation, if the girls are content and feel satisfied to remain in father's home, then I'm fine with that. But the only person who can confirm that is the guardian in a private conversation with the girls. If after speaking with the girls they confirm that they would like some time to go through reunification therapy first, then we've got an option here with the Haddock family who can take them. But the guardian needs to be able to have this conversation with the girls, and I want it to happen today. I am ordering Mr. Bishop you to accommodate this and make sure that petitioner, or rather, make sure that Mr. Wolferts goes along with it and cooperates so that this conversation can happen today. I'm certainly happy to entertain a follow-up conversation with all of these parties tomorrow. I have a jury trial that went off, so I can talk to you all first thing in the morning if you'd like to do that, so we can hear what happened with the conversation with the guardian and decide where we're going from there. But that's what's going to happen today. What time can the guardian talk to the girls? Give me a time.
So, Your Honor, I could be available to talk with them. I have another meeting from 4 to 5, so let's say at 6 o'clock this evening.
Utah time, so that would be 7 o'clock.
Sorry, that would be Utah time.
7 o'clock Kansas time. And Your Honor, can we have a time when we can have the mother have some contact with these kids?
Let's do first things first. I want the guardian to talk to them, and we can address that tomorrow.
What time, Your Honor?
Can we talk another conference call tomorrow at 9?
Sure.
Your Honor, I'm in court in Heber at 9 o'clock. It would need to be before that, and so is there any way that we could meet at 8:30 tomorrow morning?
That would be fine as well.
Does that work with your schedule?
I can do that.
And I can do, but this is Sandra Dredge. I'm happy to do that as well, but I would need to give the clerk a different phone number.
All right, so everyone's okay with 8:30 tomorrow?
Yes, Your Honor.
Yes, Your Honor.
All right, we'll do 8:30, and then Ms. Dredge, what's the phone number where the clerk can reach you tomorrow?
That's my home number. It is unlisted, so I'd appreciate it.
All right, we'll make a note that if that's an unlisted number, we'll make that a private part of the record. Thank you.
And Your Honor, I'd ask that the court call this same number that they called today. It's not my office number.
Okay, we'll use the same number for Mr. Bishop then.
Your Honor, I'd like to discuss where this should happen and how it should happen and under what circumstances, just so that there's no issue or question. I believe it's important that it occur in a neutral setting. I don't know whether the Haddocks would be available to, say, have it happen in their home, but that's at least one idea. I could certainly come up with others, maybe at the family preservation offices. I mean, that would be hard after hours, but I'd like a set as far as where it's to occur, and I would ask that the father not be in the location where the children are having that conversation with me, and it be on a phone that is not connected with the father.
I think that's appropriate. I have some reservations about having it at the Haddock home. If they don't want to stay there, they may feel awkward about telling you that if they're in the Haddock's home too.
That's a very good point.
It probably needs to be somewhere totally neutral, and I'm open to ideas.
This is Sandra, Judge. My understanding is that I believe these people live fairly close to the LDS ward. You might be able to have an arrangement with a bishop that would have a private phone with doors that can be closed and people outside of that building.
I think that sounds like a great idea.
Okay, I'm fine to approve that. Let's do that. Mr. Bishop, do you have any questions or concerns before I...
Well, I guess in the event, I mean, this is kind of a short time frame to make it happen. In the event that cannot be arranged, would the court be okay, I guess, if worst case scenario that the girls be allowed to go outside and Mr. Wolferts stay inside? I mean, they don't have a landline. All I know is he has a cell phone. I don't know if there'd be an issue as long as the guardian can confirm with the girls that they feel like they're alone and not listened to. I'm just concerned about
that's not the only problem though. They would be on their father's phone. They have no way to confirm that he's not recording, doing other sorts of things. I already have great concerns about that occurring. They need to be entirely and completely in a neutral setting.
I agree with that, Your Honor.
I've got 3 hours to figure this out. I'm just trying to work through it in the event that it's not possible.
And I would hope, Your Honor, that the LDS bishop or whomever else would be involved with this could at least talk to Ms. Borlick prior to the time of the phone call so that he understands the terms of this, so that he doesn't, so that he's really clear on what's supposed to happen here.
I think that it's best that it happen at a neutral setting, not at father's home. For the reasons the guardian has expressed, I think that makes the girls feel like they can truly have a private conversation with their lawyer. That's what I expect that they should be able to have. So let's make that happen. I'm happy to have it be at the local ward house if that's close by. Somewhere maybe even the girls could walk, then that would hopefully be something that could be accommodated even on short notice.
Okay.
Okay, and then I guess the other logistically, how do you want to set this up? Do you want Casey to call Brian's cell phone to make sure that they're at a place and then have them call back, or how do we want to make that?
Well, I'm sure, this is Sandra again. It's my understanding and belief that Mr. Wolferts has the bishop's number. He knows that bishop pretty well. He could get numbers and provide it to Ms. Borlick so that she could speak to the bishop and see if they couldn't get that put together. But my understanding is that there was a good positive relationship before the July of when this thing went down with the children and Mr. Wolferts with the church leadership there.
And the bishop may even want the girl to come over to his home and or something. I mean, I don't know, but we probably need to get a hold of the LDS bishop so that we understand, what's going to happen and how.
Well,
I'll go ahead.
No, go ahead, Mr. Bishop.
I was just going to say I'll get on the phone with him right now and try to get something arranged. Like I said, we're running out of time, so hopefully they can get something figured out between now and then.
All right,
and I'll just let him contact Ms. Borlick if there's an issue. Will that work?
I'm satisfied with that.
That would work for me, Your Honor.
All right, well, let's get that taken care of then tonight, and then we'll hear back from everybody in the morning at 8:30, okay?
Your Honor, may I just clarify one more thing? I'm so sorry. The court indicated that if the girls want to stay at their father's home, etc. I just would hope that the court, I will be reporting to the court with candid detail as far as how our conversation went. I would just ask that the court save its determination as far as whether the girls can make whether they themselves can make that determination, having been in the environment in which they've been in the presence of their father under all these circumstances. I would just ask that the court wait to say whether or not it all depends on what the girls say tomorrow until after I've reported to the court what the girls have said. And again, if they tell me that they want to stay with their dad, I will tell you exactly what they said, how they said it, and then the court can make her determination after that.
That's what I intend to do.
Okay, thank you.
Thank you, Your Honor.
All right, thank you. We'll talk again tomorrow.
Okay,
Okay,
thank you.
thanks.
Okay, bye.
Bye.